Well, hello, good evening, welcome. This is Ghana Tonight. We're live from Onisabata Desawe Kanda, also live on TV3 Ghana on Facebook and on DSTV channel 279. We're all across the world on 3news.com. I am Alfred Okansi. Tonight, the Electoral Commission of Ghana set December 30 for the rerun of the Pandai parliamentary election, even as the minority continues to rally behind their now unseated colleague. Well, stay with us. Got a conversation on this matter tonight. Also, President Mahama has described calls to scrap the OSP, that's the Office of Special Prosecutor, as premature, even as the majority leader and his chief whip moved to sponsor a bill to abolish the office. Well, we have more on this developing story tonight. Stay with us. Also, the President, John Dramani Mahama, has sent the law scrapping the COVID-19 levy. What are the next steps to be taken before Ghanaians begin to have some relief? Or at what point exactly would we stop paying for the COVID-19 levy? Is it after today, as it's been accented to? Well, we'll tell you, because we have a top official of the Ghana Revenue Authority, a commissioner for that matter, is going to be joining us tonight to have a conversation on what next after today with regard to this COVID-19 levy. Well, as always, you're an integral part of the conversation. Let's hear from you. Keep the conversation going. It's Ghana Tonight on Facebook and on X. Let's get talking. Well, let's settle for Ghana Briefs.
The Electoral Commission has set December 30, 2025 to rerun the Pandai parliamentary election. A Tamale High Court on November 24 ordered fresh polls after it found the elections won by the MPP candidate in 2024 was marred by irregularities. Parliament has since communicated the vacancy to the electoral body, sparking a wave of protest by the minority. The EC has in a statement indicated that it intends to comply with the court order by holding the elections for only the three candidates who contested the 2024 polls. Two leaders from the majority caucus, Mahama Yariga and Roxanne Nelson Dapiamekbo, have drafted a private member's bill to repeal the OSP Act and abolish the office of the Special Prosecutor. It follows days of intense public and political demand for the office to be abolished. Meanwhile, President John Dramani Mahama says the calls for the scrapping of the office of the Special Prosecutor are premature.
And so that's why we're resourcing the Economic and Organized Crime Office and the other anti-corruption institutions, including the Office of the Special Prosecutor. And recently, there have been some controversy with the Office of the Special Prosecutor. I think it's premature to call for the closure of that office. The unique thing about that office is it is the only anti-corruption agency that has prosecutorial powers to be able to prosecute themselves without going through the Attorney General.
Former Attorney General Betty Modi Drisu has accused Parliament of failing women by refusing to pass the Property Rights of Spouses Bill, which ensures fair distribution of property in cases of divorce or death. She says the delay undermines efforts to protect women's rights and called for intensified advocacy against gender-based violence. She was speaking at the 40th anniversary of the International Federation of Women Lawyers, FIDA.
Parliament, not me and you or a private member, Parliament should enact legislation regulating the property rights of spouses upon dissolution of marriage. I stood in Parliament that same 2009 to present that bill. As the guy said, Kebashimene. Up till today, zero.
The Transport Minister, Joseph Bukari Nikbe, has announced that a minimum of 8 buses will be deployed along 4 major road corridors starting from today to convey commuters back home after work during the peak hours. This has become a crucial intervention following complaints that some drivers are exploiting passengers by charging higher fares during the peak hours, most of whom are not recognized with any transport union.
We are going to employ some buses commencing from today, 10th December, and we will ensure that those buses are available at the peak hours to support our commuters who have closed from work to get home safely. And the Ministry of Transport is doing this in collaboration with the Intercity STC. Some of their long route vehicles return at good times and their schedules are for the next day. We are ensuring that we'll mop up all those vehicles and ensure that they are on our routes.
Board Chairman of Cocoa Board, Samuel Ofosu-Ampofo, is calling for stronger collaboration with regional security councils in order to effectively combat the smuggling of cocoa and farm inputs. Speaking during working visits to the Western region, he warned that the Cocoa Board's $5.8 million free input program is currently at risk as smugglers tempt farmers with quick cash.
We have realized that there hasn't been enough coordination and collaboration between Cocoa Board and the regional security councils. So some of the regional ministers don't even know our cocoa officers. They don't know our regional managers. They don't have any idea when our inputs are brought and what type of inputs to enable them to also put their monitoring mechanisms in place to help us. Unfortunately, through our interaction with the regional ministers in the regions that we visited, it appears they know very little about the special service and the work that they do.
There's more news on 3news.com. Make some time and visit 3news.com. This is Ghana Tonight. We're live on 3news.com, also on TV3 Ghana on Facebook and on DSTV channel 279. We're all across the world on 3news.com. We're on 3FM 92.7. As always, probably brought to you by Flamingo Paint, Simply Superior, Sasso Insecticide Spray, and Qualcomm Tum Precom. Coming up next year on Ghana Tonight, President John Dramani Mahama earlier today has waded into this whole conversation about the Office of the Special Prosecutor, its constitutionality, importance, impact, and achievement in the fight against corruption. Is calling moves to scrap the Special Prosecutor's office as premature. Yet, a draft bill to abolish the office is already in the works. So that's the development right now, and it's a very interesting time and how things are playing out, because this is the president's position that, you know what, this calls for the OS, that's the Office Special Prosecutor, to be scrapped. It's premature. Yet on the other side, his own party's leadership in Parliament, at least two of them, the majority leader and the majority chief whip, are also having a different mind of their own. But it's a very interesting development as we're seeing now. We've seen Nelson Roxton Dapiampo, the majority chief whip, the South Day Member of Parliament, Mama Yaraga, but the two of them have drafted a private member's bill to repeal the OSP Act and effectively abolish the Office of the Special Prosecutor. Now, it follows days of intense public and political demand for the office to be abolished. Now, we've intercepted a draft of that bill, and we're going to tease out the specifics and some highlights for you. But first off, let's take a listen to the president make this his position, or his opinion, as a matter of fact, earlier today at the Jubilee House. Take a look.
And so that's why we're resourcing the Economic and Organized Crime Office and the other anti-corruption institutions, including the Office of the Special Prosecutor, and recently there have been some controversy with the Office of the Special Prosecutor. I think it's premature to call for the closure of that office. The unique thing about that office is it is the only anti-corruption agency that has prosecutorial powers to be able to prosecute themselves without going through the Attorney General. And so people had mistrust for the Attorney General because the Attorney General normally is a member of government and is a minister of state. And so they believe that the Attorney General will be very reluctant to prosecute his own. But if there's an independent office like the Office of the Special Prosecutor, it won't matter who you are because they have security of tenure and they have prosecutorial powers, whether you're a member of government or you're a member of a previous government or you are anybody who has, misappropriated public funds. They have the law is behind them to be able to prosecute you. So I think we should give them a little time. Of course, people want to see, more prosecutions and more results. And so I'll just urge the OSP to speed up, some of these investigations and, show people that the office is still very relevant.
So that's the president's view there, Michelle. Speed up investigations to impact on the trust that people have for the office. But his view is that, well, it's premature to call for the scrap of the Office of the Special Prosecutor. Bear in mind, exactly a week ago today, we were here on this show asking about the whereabouts of Martin Luther Kwebu, the private legal practitioner, because the OSP had detained him at a National Intelligence Bureau facility. And then, just around the same time, on Ghana Tonight, the former Speaker of Parliament, Professor Aaron Michael Quay, who presided over this entire process of passing the act that set up the Special Prosecutor's Office, he joined us and said, you know what, upon hindsight, I think that, well, I sat in the chair, presided over the process, but in my view, over time, seeing the Special Prosecutor's Office work is that, you know what, it's outlived its youthfulness. Let's let it go. And then think about strengthening the Director of Public Prosecution and then also the Attorney General's Office to do the work that the Special Prosecutor is doing. Well, the President has a different view. But when the President was talking earlier this afternoon, these two honorable members of Parliament, the Majority Leader, Mama Yariga, and the Honorable Nelson Roxon Tapia-Mepo were also on a path, a different path from what the President was thinking. And this is it. They are sponsoring a private member's bill. The effectiveness of this bill and what they intend to achieve is that the Office of Special Prosecutor should go. And here are the justifications. The Office of Special Prosecutor has incurred, we're going to put that on the screen right now, high operational costs with limited demonstrable impact relative to its budgetary allocations. That's the first justification. They also say operational experience has revealed persistent challenges, including duplication of constitutional prosecutorial functions. And take note of that because we'll come back to something related. Duplication of constitutional prosecutorial functions, institutional friction. And you remember I talked about this institutional friction, had this whole unnecessary, tough war between themselves, the OSP, the Attorney General's Office, and IOCO, sometime last year when on this matter of Cecilia Dapa, if you recall. That friction they talk about. And then in this year as well, there's the Deputy Attorney General, Dr. Sremsai, talking about the extradition process of Ken Ofori-Atta and that they had asked some documents, the docket from the Office of Special Prosecutor, they were yet to receive it. All of that is pointing to this friction that he's talking about. And the jurisdictional overlap, resulting in delays and inefficiencies. And then also, they say, consolidation of all corruption prosecutions under the Attorney General to enhance efficiency, accountability, coordination, and prudent use of public resources. So this ties into what the former Speaker of Parliament, Right Honorable Professor Aaron Michael Quay, was recommending, that we've gotten to a point where instead of just having the Special Prosecutor as an office on its own, why don't you then consolidate all corruption prosecutions under the Attorney General to enhance efficiency, accountability, coordination, and prudent use of public resources? Prior to the establishment of this OSP, all these arguments came to play on the floor of Parliament, that the DPP, that's the Director of Public Prosecution, should be strengthened. It can do the job of the OSP. All of that came. But at the time, 2017, we're clear that this is what we wanted. So all of these justifications that is captured in this private member's motion that Mama Yarga and also Nelson Russell are sponsoring is just a recap of arguments we've heard in the past. They also say that this would help in the reduction of administrative overheads by eliminating parallel governance, logistics, and support systems to ensure better value for money. These are the justifications that the two senior, in fact, the leaders of this parliament are financing for. They're sponsoring this private members bill to have the special prosecutor's office scrapped. This is it. But there's something else that's happened this evening. Just about an hour ago, the Deputy Attorney General, Dr. Justice Adam Sremsai, posted this, that this private legal practitioner, Noah Tete, is testing the law. Beyond what's happening in Parliament, there's another development as well, this time around in court. And here's what Noah Tete is asking for, that he is questioning the independence, essentially, of the Office of the Special Prosecutor. That with the writ that is filed at the Supreme Court, they're seeking the declaration, or he is seeking the declaration that the Office of Special Prosecutor is not, in fact, independent of the Attorney General. That is the major relief that he's seeking, that the OSP cannot operate in and under the umbrella of independence from the Attorney General. And here's why. He references Article 88(1), 3, and 4 of the 1992 Constitution, and I quote, "There shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to the government. The Attorney General shall be responsible for the initiation and conduct of all prosecutions." Remember, one of the justifications for this private member's motion by Dafia Mekpo and Mama Yarga, they talk about prosecutorial powers. This is it. Now, 3, all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by the Attorney General in accordance with any law. So any other person who is prosecuting in the name of the Republic cannot do that on their own. It must be under the delegated authority of the Attorney General and not an independent body for that matter. So he puts emphasis on this, Article 88(1), 3, and 4. And if you look at the Special Prosecutors Act, in fact, the act that establishes the Office of Special Prosecutor, this is where the relief is seeking to address. And this is it, that except as otherwise provided in the Constitution, the office is not subject to the direction or control of a person or an authority in the performance of the functions of the office. So then, where lies the delegated authority that the Attorney General would give to the Office of Special Prosecutor if they're not going to be subject to the direction or authority of any other person? Well, it goes on to say that subject to Clause 4 of this same Article 88 that I read earlier, the Office of the Special Prosecutor shall, for the purposes of this act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses. So to this extent, the relief is seeking a declaration whether or not, indeed, the Office of Special Prosecutor is independent in the sense of the word. Well, so we'll see how the coming days will look like on this. But thankfully, Martin Kpebu is joining us. He's a private legal practitioner. Before we hear from Martin Kpebu, this is what the Speaker of Parliament, Right Honorable Alban Bagbin, said sometime last week regarding the constitutionality of the Office of the Special Prosecutor in itself. Take a look.
In fact, this morning I heard you people talking about one of them, that is the OSP. And if you recall, during the deliberation on the OSP, a number of us stated on the floor of this House that there's no constitutional basis. But we wanted to signal to the world that we are going to fight corruption. At the end of the day, we have seen the results. And we cannot continue to allocate that huge sums to the same office when we are not getting the results. This is one of the agencies we should be looking at. It's getting almost the same amount like the Attorney General's Department. Please, let's face.
So that's the Speaker of Parliament's view on this. And Martin Luther Kpebu is joining us on Zoom right now. Council, good evening. Thank you for joining us here on Ghana Tonight. Exactly a week ago, at some point, you were nowhere to be found. We were looking for you all over the place until we got to know that you were at a National Intelligence Bureau facility. Now, 1 week on, how's the reflection been like for you?
Oh, my resolve to continue the fight is even grown stronger because, as I've always known it, the third president of the U.S., Thomas Jefferson, is acknowledged to have said that from time to time, the tree of democracy is watered with the blood of villains and patriots alike. So as you fight, corruption will fight you back. Yeah, now I'm sure 1 week Kisi Jabi is in his smoothness level. He and Albert Akrugu, Sami Darko, right? Yes, they've seen, and then Abraham Ablomesa, they've seen their smoothness level. Ghana is shown that we are stronger than the four of them combined. That public office is not for a power trip or power plea, or we show you where power lies. And also, you see how the conversation has blossomed. It's good. Honorable Ayaga and Honorable Dafiameko have also taken it to a different level. And the president of Ghana has waded in. So bottom line, by the time we are done, minimum, we'll get better reforms so that the law will be better, so that the fight against corruption will be stronger. So that's where we are headed for.
See, and you reference what the president said. He says it's premature to call for the scrapping of the Office of Special Prosecutor. I know that's not your demand, but then again, it's coming at a time when the current speaker and the former speaker who presided over this whole process of establishing the office in Parliament says it's time to do away with the office because it's outlived its usefulness. Now, how does this strike you, especially because of these positions that have been espoused and what is even happening in Parliament right now with the leadership of the NDC?
It's good that, as I said, for me, is the conversation. You see, whatever it is the conversation, and the conversation is leading to improvement. So you see, for the president to come out and say he had to, because if he didn't, you see, some people have started saying, hey, these are the politicians. They want to gather around and repeal the law so that they can have a free day to be able to loot us, etc. You've heard those conversations, right? So I'm sure the president has come out early in order to stop giving currency to that argument. But our representatives, that's the MPs, also deserve to have their say. So those who are saying they want the repeal, when they go and move the motion, do all those things, they will have their say. So that at the end of the day, we'll compare all the arguments and then see what to do. But like I said earlier, even if, we are not doing the repeal, and it appears majority of the people will say, let's not repeal, it will lead to changes. Some of the greatest changes will be, like you said, this abuse of power to arrest anyhow, abuse of power to arrest when OSP doesn't have the mandate to prosecute for obstructing an officer, right? Things like he alone will see the petitions. So if he sits on a petition, he suppresses it, that's the end. We'll have changes in the law so that when a petition is presented to OSP, a committee of maybe 10 persons will see it, so that the chances of one person being able to suppress it will be almost done away with. We'll be able to get other changes, such as the appointment process. That's also very important, so that we'll stop appointing people who are too linked to politicians. Like Kissie Jabin, he was too linked to Gabi, too linked to Furiata, because he worked for these two people. This is the last time we will appoint such a person, because you see the conflict will affect the work to the extent that he cannot even shout to stop Furiata from traveling. And by saying that, Mr. Okansi, please, when you go to Makola, effective communication, when they want to arrest somebody who has committed a crime, they say Julo. They haven't said the person is guilty. They know it has to go to court. But that's how we say it. So in this case, Kissie was supposed to say, hey, Julo, Ebio Kromfo, Munchenomame to Ghanaians, so that will help him. As to whether Oforiatta is guilty or not, the court will decide. So those are some of the changes, and a lot more. We don't have time to be able to go through all. So for me, minimum, we'll get vast improvements in the law, and that's not bad. If Ghanaians finally decide that it is scrapped, I'm sure the arguments will show who wins the debate.
It's also important that you ended at that analysis that, well, the market language will still be tested in court eventually. But then again, there's something interesting that's happening, right? And Council, and quickly before I let you go, the president today says, in my view, my opinion, it's premature to talk about scrapping the office of the special prosecutor. Then, on the other hand, you have leaders of his party in parliament, the majority leader and the majority chief whip, also sponsoring a private member's motion to scrap the office that the president says, you know, in my view, it's premature. How do you see the path of this particular two divergent views traveling in the days ahead?
I expect the MPs to go on. It's a debate. Remember, the president has come to state his opinion. He has not publicly, and that would even be undemocratic, asked the leaders to stop. And we don't want the conversation to stop, no. So let the conversation go on in parliament. And as I've said, others will weigh in, okay? Others will weigh in. So, we all know that generally President Mahama's record on freedom of speech, etc., is better than the previous president, right? So Mahama has not come out to stifle the debate. He has come to remove his mouth from the debate because, you know, people already accusing him. So Dafia Mekwa and Honorable Ayariga, I'll be going to give them support. That, for me, as I said, let more people weigh in. You see the changes I've already mentioned. If at the end of the day we agree that let's do middle of the road, me is the changes I'm looking at, bottom line. Because, you know, I've already had my say where I said, because it's good to do division of labor. So instead of having less than 2,000 prosecutors and the Attorney General, if you divide it, Yoko has 500 prosecutors, OSP has 500, etc. The head of the OSP, okay, supervising 500 prosecutors is likely to do a better job than, let's say, one man supervising 2,000 prosecutors in one Attorney General. So me, I've made my argument based on economics that generally division of labor brings about efficiency, better outcomes. So that's the argument I'm making. But the others also weigh in. So division of labor, meaning that we should keep the current system where we have Office of Special Prosecutor, where we have Attorney General, and where we have Yoko, etc. Even possibly a fourth institution to be in charge of asset declaration laws, you know, those things too, because Shraj is inundated, right?
Right.
Mm-hmm. So I'm in favor of this.
Okay.
But let other people also come in, and then we would see how it goes. We'll see which argument is superior.
And these are the divergent views, obviously. That makes the democracy what it is. Thank you. Thank you for joining us. Martin Kpebu is private legal practitioner. Thank you for joining us here on Ghana Tonight. And as I indicated a week ago, we're all over the place looking for you. But have a good night. Thank you. But if you recall, some members of parliament on the floor of parliament last Thursday commented on the OSP's arrest and detention of the man we just spoke to. The very existence of the office came into question, for which the Speaker of Parliament urged members to take steps to scrap it if they found its existence irrelevant. Right? Let's recall that, okay? And we'll take a look at this, and it tells you a clear path on what the next step will be going forward. Take a look.
In fact, this morning I heard you people talking about one of them, that is the OSP. And if you recall, during the deliberation on the OSP, a number of us stated on the floor of this House that there's no constitutional basis. But we wanted to signal to the world that we are going to fight corruption. At the end of the day, we have seen the results. And we cannot continue to allocate that huge sums to the same office when we are not getting the results. This is one of the agencies we should be looking at. It's getting almost the same amount like the Attorney General's Department.
Well, that's the Speaker of Parliament, and we'll wait to see how all of this plays out and how it crystallizes over time. But coming up next year on Ghana Tonight, earlier this evening, the Electoral Commission has set December 30 for the Pandai election rerun, while the minority rallies behind their unseated Member of Parliament. Now, this is some detail that is coming up right now. We got notice from the Electoral Commission earlier today. So stay with us. The EC has set December 30, that's 2025, to rerun the Pandai parliamentary election. And a Tamale High Court on the 24th of November, as you might already be aware, ordered fresh polls after it found the elections won by the NPP candidate was marred by some irregularities. Parliament has since communicated the vacancy to the electoral body, sparking a wave of protest by the minority. Yesterday we saw that spectacle in Parliament. In fact, the chaos that we saw, all because of the development with Pandai, the clerk writing to the Electoral Commission about the said vacancy. The EC has, in a statement earlier today, indicated that it intends to comply with the court order, and we'll have that in a bit on the screen shortly, by holding the elections for only the 3 candidates who contested the 2024 elections. Well, we'll get into the details of that statement by the minority, but let's take a listen to the Deputy Minority Leader, Patricia Piaget, who spoke to the media. In fact, she addressed a press conference earlier today about this exact Pandai matter, what happened yesterday, and their decision to now cooperate, but then they're making demands. Take a look.
In the case of Samuel Nyemekan of Welensee, after the High Court voided his election, he filed an appeal. What did this House do? It continued to recognize him as a sitting MP throughout the entire appeal process. In the case of Eric Amwating of Nkranza South, detained abroad on serious charges, this House resisted calls to declare his seat vacant while his legal status was unresolved. Vacancy occurred only upon his own properly executed resignation. In the case of Dana Wodapi of Keta, convicted and sentenced to 10 years imprisonment, this House did not treat the conviction as an automatic trigger. When he was granted a presidential pardon, he returned to this chamber on 10th of June 2008 and was permitted to sit and perform duties as MP. In the case of Adamu Dramani Sakande of Boko Central, The honorable member continued to serve in Parliament for years while the courts determined civil challenges to his eligibility. Defer any action until the appellate process is conclusively complete, respecting the precedent set across decades. We need to recognize that this premature notification violates the separation of powers, disrespect to the judiciary, unjustly disenfranchises the people of Pandai, and betrays Parliament's own tradition of constitutional caution. This House is constitutionally, legally, democratically, and procedurally bound to withdraw the premature notice issued to the Electoral Commission.
That was the press conference by the minority earlier today in Parliament. But this was before. This statement came after this press conference. But the Electoral Commission has made their position quite clear on what's happening in Pandai, and this is it. They're informing the general public that following the Tamale High Court ruling on Monday to 24th of November, ordering a rerun of the Pandai constituency parliamentary elections within 30 days. And upon receipt of a letter from the clerk to Parliament, Tuesday, 9th December, formally notifying the Commission of the occurrence of a vacancy in the membership of Parliament, the seat of the constituency in Parliament has become vacant. That's what the Electoral Commission has said now. Effectively become vacant. The Electoral Commission will hold a rerun of the parliamentary election in the Pandai constituency on Tuesday, 30th December 2025. That is a statement from the Electoral Commission now. Meanwhile, here's what we got notice of. The Tamale High Court has set December 18th, the 18th of December, that is 8 days away from today, to rule on the matters relating to this particular issue, Matthew Nyandam's application for the stay of execution. Well, we have some information on this. Justice Abdullah is a private legal practitioner. He's joining us on Zoom right now for a quick conversation on this development. Thank you so much, Justice Abdullah, for joining us here on Ghana Tonight. Prior to this release by the Electoral Commission, the NDC candidate had actually questioned the EC silence on this matter, citing them for contempt. And then, just before the day ends, we got this notice from the Electoral Commission that December 30 is going to be the day for the rerun of the parliamentary elections in the Pandai constituency. Now, how do you see things playing out, especially in the coming days, taking into consideration all the suits at play?
So this is how I would like to put it. I do not see contempt in this matter at all. And I say this on the basis of what is out there in the public domain, because I do not know privately if there are any other matters going on. Now, when an order of a court is made, until that order is served on the party requiring to conduct or perform the order as made, the order remains on paper. On paper, it's ineffective. So a party that seeks to ensure that the orders of the courts is obeyed has an obligation to get the order drawn up and have it served. Now, in this particular case, we have three main parties to this case, even though one of the parties is not in the suit, i.e. Parliament. You would have to obtain the order, serve it on the Clerk of Parliament, who would then also have to inform the EC of the existence of a vacancy. And you'd also need to serve the EC with the same order, based upon which the decision made by the court can then be implemented. Now, until these procedures are complied with, nobody can talk of a contempt, because you need to be aware of what you are required to do in law before you can be said to have disobeyed the orders of the court. If you're not aware, you cannot disobey. It's a different angle of contempt, of course. There are other forms of contempt that could arise under different circumstances without necessarily an order having to be made. But in this particular case, this is what we are dealing with. And this is why we limit our discussions to. Now, if you move on from this, the EC setting the 30th day of December for the rerun of the election. It sounds a bit problematic to me, because I am aware that the EC is automatically a party to the suit, both in the Court of Appeal and the High Court. I've not seen the Supreme Court application, but I would assume that the EC will be made an interested party in the Supreme Court issue, even though he's not directly a party to that, but he'll be made an interested party by virtue of the role he plays in the rerun or otherwise of the election. If you put it, if you take it from that angle, with a notice of appeal having been filed, an application for stay of execution having been filed, and then the certiorari that had also having been filed at the Supreme Court, any conduct by the Electoral Commission that seeks to outreach any of these applications could amount to contempt of court. And for me, that is rather more dangerous than all the things that are being bandied around within the public space. Because if an electoral commissioner that is a party to a suit, you have been served with an application to stay your hands, what is required of you is to wait until the application is determined. And so any attempt to execute the judgment of the lower court pending these applications could amount to a contempt of court.
I see. But, but then again, the hearing of the application is before the set date of this election rerun. The hearing of the application is on the 18th of December. The rerun date that has been announced today by the Electoral Commission is on the 30th of December. That's some 12 clear days away. And so why do you draw the correlation between what is going to happen in court and the question of contempt on the part of the Electoral Commission?
Admittedly, the dates for the rerun is far ahead of the hearing of these two applications. We might not get to that point. But the position is that if these applications exist and the EC goes ahead to conduct the elections, the EC rather will be committing contempt. So what I am seeing here is Parliament deflecting the dangers on themselves onto the Electoral Commission, so that everybody else will rather be targeting the Electoral Commission rather than targeting Parliament as an institution. Because the conduct that could amount to contempt could affect these two institutions. But unfortunately, Parliament is not an institution that the court, being of, if you like, of equal power with, by way of their authorities. Parliament, but the court cannot hold Parliament in itself contemptuous of the court. But of course, some individuals within Parliament can be held contempt, contempt of court. But but what you see here is an attempt to deflect and push the blame onto the Electoral Commission, for the Electoral Commission to act contrary to lay down procedures and then be held in contempt. And if at the same time they do not act, then the public sentiment will rather be targeted at the Electoral Commission for not acting when they were required to have acted.
I see.
So it's a very delicate matter, very difficult. If you were sitting in the seat of the Electoral Commission, I think arguably this would probably be one of the most difficult things you would be called upon to do, because whichever way you turn, you are confronted with a potential contempt application that could result in you going to prison or losing your job. Either way, I don't think it's a pleasant experience to be involved. And it's obvious because it's a political tussle between the NPP and the NDC, and which is what has landed the Electoral Commission into this quagmire.
Well, thank you for your thoughts. And this is a portion of the Electoral Commission's statement that captures exactly what their intention is in the coming days, right? But this is it, that whatever and regardless, December 30 is the date to look at. But if you look at the politics of things, this constituency is not one that you would say is an outright NPP or NDC, because if we start from at least 2012, right? From the 2020, maybe, let's look at how it played out in 2016. The NPP won with a very close margin as compared to what happened in 2012, where the party won with a little over almost 3,000 votes. That was closed in 2016 by some, in fact, less than 1,000 votes, 19,037 as 50.17%, as against the NDC's Kojo Teria, 18,271. This was in 2016. Now, look at 2012. I want to take a look at this. 2012, and take a note of the gap. Same Matthew Nyandam. 2012, he polled 16,371, as against the NDC's candidate, 13,794. Then the gap closed to less than 1,000 in 2016. Now, if you look at the picture, and this is 2020. 2020, the NDC changed this candidate, and Daniel Nsala Wakpal won with a margin of over 2,000 votes, after the previous candidate of the NDC closed the gap between him and Matthew Nyandam to less than 1,000, the previous election, 2016. Then we see what happened in 2024. 2024 elections also presented with a very, very interesting development as well, with now it being a matter of contest in the court of law. So we'll keep an eye on Pandai. This is your election command center. The ball is already set, rolling. So keep your eyes here across all media journal platforms. We will be in the Pandai constituency right from the get-go. For 2 days ago, we were there. We're going to stage a camp there up until December 30. So stay with us. We'll be back shortly after this quick break. And we'll go to the Ghana Revenue Authority to ask questions after the president has signed off scrapping the COVID-19 levy. When is it going to take effect? When are we going to actually stop paying the COVID-19 levy? Is it after today or when? We have answers for you. A commissioner of the Ghana Revenue Authority is joining us on the show after this quick break. Stay with us. Welcome back. President John Mahama has assented to the COVID-19 Health Recovery Levy Repeal Act 2025. Earlier today, this is what happened.
Repeal Act 2025. And it's my honor and privilege to sign to repeal the COVID levy. Promise made, promise delivered. And today is the 10th of December, 2025. Sign.
Dr. Martin Colbill Yaborija is Acting Commissioner of Domestic Tax Revenue Division of the Ghana Revenue Authority. Thank you so much, Doc, for staying up to talk to us tonight. First of all, I want to find out from you, but what the president has done now, beyond today, what next? What is the GRA going to be doing?
Thank you very much. So as you rightly said, the president has assented to the new VAT Act. So what would the GRA be doing? Number one, we are going to immediately commence sensitization exercise to let the taxpayers know about the law. Then also, we have what we call administrative guidelines that will teach or direct taxpayers as to what they should do. So in anticipation of this new law, we have already constituted a team, and the team is currently on site developing an administrative guideline that will guide the taxpayers as to how they are going to implement the law. Now, anytime a new law is passed, depending on the nature of the law, there are certain things that need to be done. In the case of VAT, because of the number of stakeholders involved, we have to make sure that everybody is brought on board. So we are going to communicate with our taxpayers, that is all VAT registered taxpayers, informing them of this new law and also telling them when this new law will come into force. And from the law, it's supposed to take effect from 1st January 2026.
I see. 1st January 2026. So that's the effective date that when we go to the supermarket and wherever we're going to buy, we will not see COVID-19 levy on the receipt. But between now and the 31st, we will still be paying.
Exactly so. Well, it was part of the 2026 budget statement. And the 2026 budget statement takes effect from 1st January 2026. So all laws that relate to that budget also take effect from 1st January 2026. And you need to also understand that taxpayers will need to recalibrate their systems to be able to take on board the new changes. Prior to this law, we had the COVID levy, which had been abolished now. We have the GET Fund and the National Health Insurance Levy. There were standalone levies charged inclusive VAT. Now those laws have now been added to form part of VAT, which is now 20%. So those who are using their own system to generate VAT invoices will need to recalibrate the system to take on board the changes. Those who are still using manual VAT invoices, we need to let them know so that when they are writing the invoice, they will not write the invoice and the VAT will be 20%, made up of 15% VAT, 2.5% GET Fund levy, and 2.5% National Health Insurance levy, but all operating under the same rules as VAT and subject to input tax deduction. Then there are people that we have also onboarded into what we call the e-invoicing system. So they will also have to recalibrate their system to make sure that they take on board the new changes to the law.
All right. Dr. Martin Kobil Yaborija, thank you so much for this clarification and as well as the education. So between now and the 31st of December, you will still pay the COVID-19 levy. The effective date for its abolition is the 1st of January 2026. This is after the president has assented to it today. So, Doc, thank you for this. Appreciate you for joining us. The Acting Commissioner for the Domestic Tax Revenue Division of the Ghana Revenue Authority. There's more of this on 3news.com. On behalf of the rest of the team, we do appreciate your company. I am Alfred Okanse. Have a good night.
Ghana Tonight is brought to you by
Flamingo Paint. Superior durability, superior hiding, superior coverage, simply superior.
Sasso insecticide spray and coil.